The U.S. Supreme Court heard arguments Monday in two cases involving affirmative action in college admissions. The outcome could potentially overturn precedents set decades ago. Jan Crawford has the latest from the Supreme Court.
The extraordinary arguments, nearly 5 hours long, were contentious as the justices grappled with whether considering race in college admissions was a modern-day form of discrimination.
We're talking about race as a determining factor in admission to Harvard.
Chief Justice John Roberts clashed with a lawyer defending affirmative action at Harvard University against a challenge by Asian students who say they are held to higher standards in admissions than whites or other minorities.
Race for some highly qualified applicants can be the determinant factor, just as being an oboe player in a year in which the Harvard-Radcliffe Orchestra needs an oboe player will be the tip.
We did not fight a civil war about oboe players. We did fight a civil war to eliminate racial discrimination.
But liberal justices suggested colleges like Harvard and the University of North Carolina have to consider race as one of many factors to get a full picture of a student's life experiences. Justice Ketanji Brown Jackson.
No one's automatically getting in because race is being used. They're looking at the full person with all of these characteristics.
The court has scaled back affirmative action over the years. It said in 2003 it should not continue indefinitely. 9 states now ban it in college admissions. But civil rights lawyer Damon Hewitt, representing the University of North Carolina, says affirmative action still is crucial.
When you think about a world without affirmative action, think about what our workplaces will look like, what our schools would look like.
But opponents of affirmative action say there are other race-neutral ways to get diversity, like focusing more on socioeconomic factors. And that was the focus of several of the conservative justices who seem to suggest the clock on affirmative action is ticking. John?
Jan Crawford outside the Supreme Court. Thank you, Jan. Joining me with more is Harvard Law School professor of practice, Alan Jenkins. His research focuses on race and the law and Supreme Court jurisprudence. Alan, thank you so much for being with us. Can you help me first with what Justice Roberts was talking about on the oboe player at Harvard? Wasn't the argument of the Harvard lawyer that race is one of the many things that are taken into account, and so for a certain student, that might be something that is taken into account, like playing the oboe. And Justice Roberts' retort about fighting the Civil War, how did that play in as a rebuttal to what the Harvard lawyer was arguing?
Well, stepping back for a moment, John, the Equal Protection Clause of our Constitution was intended to create full and equal opportunity. That vision has been frustrated by decades and decades of intentional discrimination and systemic bias. Campus diversity policies have been one modest tool for expanding opportunity and for teaching our young people how to learn and live together, something that's desperately needed right now. Many of the conservative justices, including Chief Justice Roberts, many of their questions were phrased in the abstract, as if the Civil War was fought for a vague principle of non-discrimination, as opposed to centuries of discrimination against Black Americans and decades and now centuries of discrimination against Latinx and other Americans of color. And so by suggesting that this is an abstract principle, I think the Chief Justice is really asking a misleading question. As to the oboe piece, this is part of what building a diverse campus is. If we had, 160 talented oboe players, that would be remarkable, but not a very interesting or vibrant place to learn about the full range of subjects that we try to teach at a university. And so similarly, affirmative action has been one modest tool for enabling us to have campuses that begin to reflect the vibrant diversity of our nation.
That's why it was a bit of a head scratcher, that retort for me. So if the justices are the conservative justices are likely to reduce affirmative action in college admissions, how significant of a precedent overturning moment would that be?
Well, assuming the universities lose before the Supreme Court, which is certainly a significant possibility, it's going to depend how broadly the justices rule. In the past, you've seen other courts, other justices on the Supreme Court tweak affirmative action, make it a little more difficult to satisfy. This court is signaling that it may want to eliminate all consideration of racial diversity, which would really be devastating not only for universities, but for corporations, for businesses, for lots of the places who've been seeking to achieve the benefits that having a diverse workplace generates, and particularly in the education context, to teach young people how to live together, how to learn together, and to understand a diverse nation and economy and world. And so the ramifications could be quite wide-ranging and devastating.
Were there any arguments made by those arguing on behalf of the schools that seemed to gain any purchase with the conservative justices about the benefits of diversity in school admissions?
Well, I've learned not to second guess based on Supreme Court oral argument, because the justices, by their nature, are asking tough questions on both sides. But I think Justice Ketanji Brown Jackson, for example, seemed to really pull out the history, the fact that this is North Carolina as one of the universities, University of North Carolina, where there's an extensive and recent history of discrimination in the state and by the university. And I think we heard some of the justices across the ideological spectrum responding to that reality a bit. Whether it makes a difference, we'll have to see.
All right, Professor Alan Jenkins, thank you so much for being with us.